Good evening, this is John Milburn for Laws 11057 Introduction to Law. Tonight we're into week 4. We're dealing with a whole range of issues, but I'm going to start with some commentary about the first assessment. Today, those of you who submitted your assessment should have received your mark and your feedback. If you didn't, please let me know, or better still, ask through UCrew and we'll try and track it down. The assessment was due last Thursday. So it's very unusual that I'd release any results or feedback at this early stage, given that it's still theoretically possible for people who haven't lodged their assessment to do so at a penalty of 5% per annum, per day. It won't happen again. And the reason it won't happen again is given the nature of this first assessment. The first assessment is very personal. It's your own portfolio. There's not a lot of law in it. It's mostly mastering the technology, staying within timeframes, and providing information that is relevant to you. I'm looking for some key aspects, but mostly it's quite personal. So by providing results now, I'm not really giving anything away, which would advantage those that haven't yet lodged their assessment. And given that it's it's 3 or 4 days, so people who lodge their assessment now are down by 20% anyway. So the reason that I've given you the feedback and the results early is I want you to learn from what's happened. I want you to be encouraged by the fact that you've already got some runs on the board, and we can start to focus on the second assessment. There is another reason, and that is for those of you who might be watching this after the event, and I suspect that everyone that I can see online has lodged their assessment, got their results. But for those of you who haven't, and there's only a few of you, please do so quickly and know that you've got not just me, but a group of people that are willing to help you through the technology. The other thing about releasing the results now was to build on the spirit of collegiate approach that you have already developed as a group. There's a lot of talent in this group, and I suspect that you will quite rightly look to each other for support, guidance, feedback, and assistance throughout the rest of your career, certainly your studies and into your careers. There'll be enough people for you to challenge or compete with outside this group, so it's good to develop friends within the group, and that's why I'm very keen for you to develop and foster this collegiate approach that you've already started with. So thank you very much, those of you who have submitted your work. I hope that you find the feedback useful. It's pretty basic, but I want you also to develop your portfolios into the future. Remember, of course, that there are some subjects that you can build upon from what you're doing now into the future. There is a subject in the 3rd year which is all about professional portfolio. So continue to build your portfolio, and it will help you if you do that 3rd level subject. There's a 2nd year subject called legal research. So what we're going to be doing in the next 3 or 4 weeks will help you to build on that subject as well. And of course, there is statutory interpretation. Okay, are there any questions about the first assessment, the feedback, comments, thoughts? All good? Okay, great. So we can move now on to the second assessment piece, which is the toolkit. Next week, there will be no live lecture. We're on leave. The week after that, there'll be no live lecture. I'm going to pre-record. I've mapped out my legal research video. I try to make this 1 week. I can't do it in 1 week. So last year, we did this over 3 or 4 weeks. I'm going to do the same. I'll record probably 4 videos. I'll upload those. The intention is that you work through them at your own pace, but don't just listen and play it continuously. The intention is that you stop, you start, you check things, you research it for yourself, and develop your own systems. The work that you're doing while you do that will help you directly when it comes to preparing your toolkit. So you're listening to the lecture, you're going through the process, and you are building your second assessment piece as you go. I'm going to release those early. I hope to have those released this week, so you get a jump on week 5 by 2 weeks, which will help you with the assessment. Before we can talk about legal research, we need to understand some basics. The separation of powers. I'm sure you all understand that there are three arms of government: the Parliament, which is the legislature, the executive and the judiciary. And as far as possible, they remain functionally separate. But there is a tie between the Parliament and the executive. Of the three, judiciary stands most independently. Let's have a look at something which is developed through the Parliamentary Education Office. To do this, I'm going to share the screen. I do hope that my internet bandwidth holds for this. If I start to break up, please let me know. All right, can we see, I'll just get you to shake your head. Can you see Managing Australian Law, an example? Great. That's a very simple flow chart. It's from the Parliamentary Education Office, which is federal, and just shows the example. Parliament makes a law to do certain things. An officer of the executive executes that law by acting in accordance with the legislation to do something which would otherwise be an offence. The actions of the executive officers are then prosecuted or challenged in a court where the judiciary reads the Act of Parliament, examines the process undertaken by the executive officer, and then makes a decision as to whether any laws have been broken. And it goes both ways. The laws that might be broken might be the laws broken by the defendant, or they may be the laws broken by the officers of the executive. When you're acting for a defendant charged with a criminal or quasi-criminal offence, you're always looking to see if the people that are prosecuting have actually complied with the law. And we'll give you a good example of that tonight, which shows the difference. And it shows how, this is the defence lawyer in me coming out, it shows how this can bounce back onto the executive. So everyone needs to follow the rule of law. Okay, so I would urge you to have a look at the Parliamentary Education Office. It's got some great resources. It's not just the flow charts. I'll show you some other material which I think is very useful, such as commentary about the separation of powers. Really good basic information, which is much more detailed if you read it than it might appear on the face. So do have a look at the way in which this works. For example, and it talks about the Constitution. You'll see there a reference to section 61 of the Constitution, the Commonwealth Constitution, which provides that the monarch, the Crown, holds executive power, exercisable by the Governor-General as the Queen's representative. However, section 62 provides that the monarch must act on the advice of ministers. So that's the executive function and the role of the Governor-General, explained in an interesting and easy to follow way. Apart from that, there is some further information that I'll share with you as we progress. So, in order to understand the law, you need to understand the separation of powers. Have a good grasp of what the separation means in practice, who are the players, how do they go about their function, and from where do they derive their power. So the link for the separation of powers, I will drop into the chat facility and you can see it there. From that one link, you'll be able to follow the link to the diagram that I showed you. Now, of course, the case law is determined by the judiciary. And you might wonder, in a way, this. If parliamentary law is superior to judge-made law, which it is, why do we need judge-made law as well as laws made by Parliament through legislation? Can anyone tell me why? What's the point of having judge-made or common law at all? Any thoughts? Now, if you're speaking, I can't hear. You need to unmute your microphone to accommodate for differences. Mary?
To give different interpretations, to examine the law as it's made, and to be able to, use some lateral thinking and some, thought and ideas as to how you can, put a different spin on that particular law that's been made, so that you can bring your argument for your client to the court.
Exactly. Because despite the extent to which legislation can provide detail in itself and through delegated legislation such as regulations, it's just not possible to cover the field. For example, if Parliament made a law, a very basic law, saying it is an offence to drive without due care and attention, that is a motor vehicle, then the question is, all right, well, are you committing an offence if you cause an accident as a result of a brief distraction while you changed radio stations on the audio visual, on the stereo? Do you understand? So legislation can't say you are committing an offence if you drive without due care and attention, and here's the list of 17,000 things that might potentially constitute due care and attention. So the way in which it works in practice needs to be dealt with through case law. So a magistrate makes a ruling that you are guilty of driving without due care and attention because you were momentarily distracted while you changed radio stations. That goes on appeal. The district court judge says, I agree, the appeal dismissed, you are guilty of the offence. The next time someone is charged in those circumstances, the lawyers and the court will look to that district court decision and use it as a guide to determining whether or not the person is guilty in the circumstances that they now face. Of course, you may have a situation where the Court of Appeal has given a ruling in relation to that matter which is contrary to the district court ruling. In that case, we're not going to follow the district court ruling, we're going to follow the decision of the Court of Appeal because it's higher in the hierarchy. So the decisions of magistrates and judges are not always the same. We need to consider the factual circumstances and we need to consider the hierarchy. And that's how case law and precedent works. So, Benjamin's right, legislation doesn't cover every circumstance. That's where the courts need to fill in. There is one exception to that general rule, and that is judicial activism, which is where the court will essentially create new law. Not many examples, but the example we talked about last week with Mabo is an example where the High Court created a law that essentially said terra nullius does not exist. That then became legislation through the Native Title Act. All right, so legislation overrides case law. Parliament makes an act, creates a law, and when the courts interpret that law, they refine that and apply it, they create common law or judge-made law. But if there's judge-made law and the courts have done something that Parliament does not like, Parliament can create or amend the law to override the case law created by the judges. So it can become a bit circular. All right, any questions about that? Let's look at an example. From your text, there's a case called Ridgeway against the Crown. You notice that I didn't say versus. So I said Ridgeway against the Crown. You can say Ridgeway v the Crown, but most people say and or against. But you never say versus. That is a rookie error. I tend to say and. So Ridgeway and the Crown. It's a decision of the High Court from 1994. Ridgeway was participating in a controlled importation of heroin into Australia. He was arrested because of a tip-off. Now, what happened is the authorities allowed the informer to pass through customs without being apprehended and delivered the heroin to Ridgeway, who was then arrested. The High Court quashed Ridgeway's conviction. They ordered a permanent stay of the proceedings, and what they did is they recognised a judicial discretion in criminal proceedings to exclude evidence which is against public policy. And the public policy consideration in that case was the fact that the executive officers were themselves acting unlawfully by allowing someone to go through customs carrying heroin with their knowledge and their consent and their encouragement. Do you understand? So in a sense, by strict application of the law, the customs officers were parties to an offence, or sorry, the investigating authorities were party to an offence. Now that was the High Court's decision, but the federal government overturned the effect of that decision by an amendment to legislation. And that amendment to the legislation was the introduction of Section 15X to the Crimes Act, which allowed officers to engage in controlled operations to gain evidence in those circumstances, even though it involved them being involved in and otherwise committing a serious state or criminal or Commonwealth offence. Okay, so that's an example of how we have the separation of powers, and it's an example of how we have the hierarchy of decision making and the way in which judge-made law can be overruled by later legislation. I'll leave you to read through that, but make sure that you're clear on those principles. Again, coming back to the who does what and what is the basis for their authority or their power. The reason I'm saying make sure you know the authority for the basis of their power is this. It's very practical. If you're in court and you make a submission and you say, maybe even very basic submission, well, the result of this legislation is that it overrides the previous decision of such and such. Always be prepared for the court to ask the question, why do you say that? What's your authority for that proposition? In which case you need to say something like Section 61 of the Constitution confers authority on the monarch and the executive, whatever it might be. But you need to know the basis for why people are entitled to do certain things. Any questions? All good? Be prepared to back up your claim, says Jessica. Exactly right. That's a good one. Now, let's get into some slightly confusing terminology. We'll see if we can clear it up. When we talk about law, it's a combination of primarily legislation and case law. It's more than that. There's delegated legislation, there's practice directions, all those sorts of things. But the primary sources of the law are normally regarded as legislation and case law. But then we have the common law and the judge-made law. So the common law is really judge-made law. And we also have this thing called equity, which is also judge-made law. And the common law and equity are known as the common law. So it becomes very confusing. What is common law? So the same term can be used in a couple of different ways, depending on the circumstances. So let's just take a moment to go back in history and talk about what happened in England in the Middle Ages. We had essentially black letter law, which we call the law, and it was originally called the common law, which was very strict. There were some pieces of legislation and they were always interpreted at law very strictly. It says black, it means black, it doesn't mean grey, you're guilty. On the other hand, the Lord Chancellor, basically representing the King or the Queen, had its own court, which made decisions not based on black letter law, but on what was fair, what was equitable, and what was based on good conscience. So that's what we call equity. Now, the Lord Chancellor established this court and eventually got to the stage where they had to record the decisions so that they could use them for later reference. And that's where the doctrine of precedent was born. So because the Lord Chancellor made a decision to say, well, a couple of years ago I had a similar case and this is what I did, I'm going to apply that same principle now and use it again. So we see the development of common law and equity, but it was based on equity. So then we had these two systems of deciding cases running parallel in the same country. You could either go through the black letter law process or you could go through equity. And it became confusing. And the law by King James in 1620 was basically to say, look, if there's a conflict, the law of equity prevails. So then for another couple of centuries, we had these two fundamentally separate court systems running side by side until 1873 with the introduction of the Judicature Act of the United Kingdom. So it was really late in the piece. It wasn't that long ago. So that's when law and equity merged to become the common law as we know it. Even now, we still make a distinction. We talk about equitable jurisdiction. We talk about equitable remedies. That's kind of the historical basis for that. So you'll need to get some idea of what we mean by law, common law, equity, the combination of the two. You'll read about equitable principles in your textbook. People who want equity must come with clean hands. If you want a fair and reasonable outcome based on good conscience, well, you've got to have good reason to come to the court without having committed something that is unconscionable yourself. Equity looks to the intent rather than the form. So we're not too worried about necessarily the strict wording, but what's the intention? That's sort of equitable. So have a read through your text about equity, equitable principles, and appreciate the difference between equity and law, which combine to become common law. Now, I know that's a really quick introduction to law and equity. Are there any questions? Have I moved too quickly, or can you follow that? Good? Okay. Have a look at James and Field, the new lawyer, from pages 98 to 102, which talks about the interplay between England and Australia. The Statute of Westminster, 1931, provided British Parliament would no longer legislate for the Commonwealth of Australia without its request and consent. Which is quite extraordinary, isn't it? That English Parliament, British Parliament, was still creating legislation that had a binding effect on Australians right up until 1931. In 1986, the Australia Acts came into force, both in the Commonwealth and in the UK, which effectively severed any ties between Britain and Australia. It's really odd because if you read about the Privy Council, it wasn't that long ago that the highest court in Australia was not the High Court, it was the Privy Council, which is an English court. It's the English equivalent of the High Court in England, but it deals with overseas jurisdictions. So really up until 1986, we still had formal constitutional ties with England. So that's now gone. Have a read about that, pages 98 to 102. Then go on to talk about the Australian legal system as it is now. Read between pages 114 and 144. What I want you to draw from that particularly is the 7 characteristics of the Australian legal system and try to understand what they mean. Now, these things can be useful if you're trying to mount an argument. So the 7 characteristics are, number 1, the rule of law. You'll need to understand what we mean by the rule of law. You'll hear it from time to time. And think to yourself, when you read these things, how can I use that when I'm trying to advance an argument? That's really what it comes down to. And there's some good chats on the chat facility. Were the ties fully abolished with the Constitution in 1900? No, they weren't. And it is quite amazing they weren't. It was really only in 1986 that we abolished ties with the UK. And that's right, Benjamin's right. In 1900, what happened is we got our own federal parliament and the Constitution. But it was a Commonwealth, so it was a UK Act that created our Constitution. All right, so number 2, liberal democracy. Number 3, common law legal system. Number 4, constitutional monarchy. Number 5, federation. Number 6, separation of powers. We've dealt with that. Number 7, responsible government. So if I ask you a question about constitutional monarchy, what does that mean? You need to know. What do we mean by liberal democracy? What do we mean by separation of powers? So read actively and create something that you can refer to when you need it to support an argument that you wish to make. Those 7 characteristics are defined at length in your textbook. Your textbook's great for that. Okay, let's have a break for 5 minutes. Not literally, don't go away, but just have a break from what we're discussing. I'm going to pose this to you, and it may have happened already. You're at a barbecue, whatever. You're having dinner with some friends, you're at beer after golf, whatever it might be. You're studying law. Oh, yeah, law. I've got a legal thing for you. And what happens is that somehow people expect you to know all the law. It's quite amazing because they'll be talking about some specific thing and they'll be talking about the law and say, well, as you know, the law says this. Well, you know, I don't know all the law. I wouldn't know anywhere near 1% of all the law. No way. So when you're talking with someone who deals with a specific area, they may well know the rules and the regulations to a much greater extent than you could ever hope to do, even though you've got a law degree and you're practicing as a lawyer. So bear in mind that you should have you manage the expectation of yourself and others. Manage your own expectation. Come to the realization now that if you're like me and you study, practice, read, teach, or whatever law every day of your life, which is pretty much what I've done since I've been 17 years old, you're not going to come close. So don't even try. But what you do want to try is to learn how to research the law and become an expert on that. So when we move through the end of this course, this unit, I want you to feel that you are experts in legal research. So when people say, oh, as you know, Regulation 27 of the blah, blah, blah regulations says this. No, I didn't know that, but I could tell you, I could research not only that regulation, but I could research the cases that relate to that legislation. I know how to do that. And then I could have an expert answer. Anyway, that's just a digression, and it's a little segue into what we'll be doing in legal research soon. Intermission's over. Let's get back to it. So the primary and secondary sources of law, we know what they are. What are the primary sources of law? Anyone want to tell me? Yes, Craig?
Case law.
That's one of them. And Jessica's got the other one, legislation. Great. So primary sources of law, legislation and case law. Thank you, Craig. Thank you, Jessica. What's a secondary source of law? Any examples?
Internet.
Internet. Yeah, well, that's pretty broad because legislation and case law is on the internet as well.
Ostley.
Ostley, legislation and case laws on Ostley as well. But Ostley has other things and internet has other things which do comprise the secondary sources of law. You're on the right track. Benjamin says reports, texts, essays. Good. Tim says textbooks. Good. Journals. Yes, these are all secondary resources. And Craig's right. You can find a lot of these things on the internet, and more specifically, you can find a lot of these things in Ostley. We all know what Ostley is. We've all had a look. It's great. Okay. Books. Okay, so keep that in mind. Primary and secondary sources of law. If you're arguing a case or a position, always argue where you can using primary sources of law. You can support your arguments by reference to secondary, but you wouldn't normally lead your argument based on secondary sources of law. Am I telling you this just to make you better lawyers on your feet in front of a judge or a magistrate? Well, partly, but it's also because I want you to be better students of the law and I want you to get better marks when you're doing your legal assignments. So if you're asked a question to give an advice in relation to a factual scenario, for example, and write an opinion about something, you're not going to start by referring to the new lawyer. As good as it is, that's a secondary source of material. You're going to start by referring to the legislation and the case law, probably in that order, I'd suggest. Then you might support it with material which is from journals, textbooks, reports, essays, and things of that nature. So keep that distinction in mind and make sure that you approach your arguments using that degree of logic. Soon, when you complete the task of legal research, you'll know exactly where to find the primary and secondary sources of law that you need. And you'll be incorporating that into your flowcharts and information that you prepare for your second assessment piece. Any questions? You're doing well? All good? All right. So, a couple of questions coming in. Is off the record included secondary source of law? Not sure what you mean by that, Annie. Do you want to unmute your microphone?
Yes, what I mean, John, say, for example, someone has said, for example, one of the law, we haven't seen the legislation yet, but someone has told me, oh, look, by the way, say, for example, RTA law, this is what it says. This is just been told. This is off the record, I mean.
That sounds, at best, a secondary source, and it may not even be a secondary source. It might just be something that you can use and adopt for yourself, but certainly wouldn't be a primary source. But thank you, Annie.
Thank you.
And Jessica says, is that like a building a case based on law alone? Then introduce your particular case? Yes. If we think of the IRAC method, and we talked about IRAC, didn't we? Issues, rules, application, conclusion. When you're looking at a legal problem, identify what are the main issues and then identify the rules. It's at that stage, when you're identifying the rules, that I want you to lead with your highest trump cards, legislation and case law. Then talk about the secondary materials under the heading of rules. So yes, Jessica, it is like building a case on the law, and then you apply it to come to your conclusion, which is the A and the C out of IRAC. So, legislation. You need to consider a few things when you're reading legislation. Those of you doing statutory interpretation will be knowing all about this by now, but you need to read the Act. So, for example, the Acts Interpretation Act. But you need to consider things like the commencement tables and government gazettes, and certainly amendment acts, second reading speeches, explanatory memorandum, Commonwealth, or explanatory notes, Queensland, which all work together when we're talking about the primary source of law, legislation. Sometimes you need to consider the timing of the legislation as well. So if you're dealing with a factual issue which is from 1985, then you're looking at the law in 1985 and you need to work out what that law was at that time by reference to the legislation, which means that we need to interpret the legislation, which is the whole subject of statutory interpretation. And for those of you doing it, this might be a bit basic, but you need to consider the purpose or the object provisions. Where would we find, this is an easy question for those doing statutory interpretation, where do we find the purpose or the object provisions typically? Where's the first place we look? Purpose and intent, yes. But where do we find a statement of that purpose and intent? Hansard wouldn't be the first place I'd look, but you'd certainly find it there. Table of contents, we're getting closer. And in that table of contents, what are we looking for? What in the table of contents? And are we talking about the table of contents for the legislation? The objects clause, that's what I'm after. So normally section 3 is the objects clause. Then there might be interpretation provisions, really easy for those doing statutory interpretation. Usually a dictionary contained within the Act itself. Schedules, exactly. And then we look to the extrinsic materials. So intrinsic meaning inside the Act, extrinsic outside the Act. What's an example of extrinsic material? We've already had one from Jessica. What's an example, Jessica, of an extrinsic material? Explanatory note, yes. Hansard, yes. So they're extrinsic materials. They're not within the Act, they are outside the Act, but relevant to the Act. Does that make sense? Second reading speech is also an example of an extrinsic material. So I hope I haven't confused you there. So when you're interpreting legislation, the starting point is to look at within the Act and start with the objects clause. Have a look at the dictionary. That's all intrinsic. It's built within the Act. And then you go a bit broader, look at the outside material, extrinsic material, such as Hansard, explanatory memorandum, etc. Okay, now are there any questions or comments? For those of you doing statutory interpretation, you'd be saying, that's so easy. For those of you just doing introduction to law, you'll be going, well, slow down, I can't follow you. So if you're just doing intro, just do some background reading to that. Now, are there any questions? Jessica, do you have any questions? We're good? Okay. All right. So what I'm really saying is that it's all very well to know that legislation is a primary source of law and legislation overrides common law. But by that brief discussion, I've said you really need to understand how to read legislation. Let's share the screen and allow me to show you something that I think is really good. Can you see the separation of powers screen there that we looked at before? I've got the right screen. I'll get rid of that and we'll go to this one. How to read legislation, a beginner's guide through the Parliamentary Council's Office of Western Australia. It's a little old, but it's still very good. I love the opening statement to this. Have a look at this. It's very comprehensive. Introduction. A lady called Lisa asked if there was a book with the basics about how to read and understand legislation, something like How to Read Legislation for Dummies. What a great start. This publication tries to be a beginner's guide for readers of legislation, and it explains things very simply and shortly. I love introductions like that. That, to me, reads like a Lord Denning judgment. And you think, wow, this is really good. This is really pitched at the right market. So how to read legislation. And I know you're going to say, can you please give me the reference to that? So I've just put that in the chat facility. So you need to understand how to make legislation, do some outside reading. The text is good, but there are other resources as well. You'll need to know the process. A bill is a draft of legislation. It progresses through, the bill progresses through a few things before it becomes an act, if it does become an act. Not all bills do become acts. But what are the things that it needs to do, a bill, on its way to becoming law? What are some of the steps? Any thoughts? Be introduced, first reading, yes, yes. Needs to be approved by both houses at the Commonwealth level, be debated, which is through that process of being approved, be read and passed by both Houses of Parliament? Exactly. Now, why am I saying both Houses of Parliament are Commonwealth? Distinguishing it from what? Queensland. Commonwealth is bicameral. Queensland is unicameral. We don't have a Senate in Queensland. Okay, unicameral, that's it. Upper and lower house in the Commonwealth, different terminology being used. But that's right. So a bill is introduced. There are a few readings. First, second, there'll be a debate. It usually goes to a committee, possibly a third reading, ultimately becomes law. Once it's passed through both houses or just the lower house in Queensland, and becomes law when, we talked about this last week, assent. That's it. Thank you, Ben. Where do we look to or proclaimed? Where do we look to determine the date of assent or proclamation? When does it become effective? First place we look. Oh, we do have second readings in Queensland Parliament. In Queensland, we go through the same basic process, except we don't have an upper house. But we still go through the first, second reading, speech, etc. Commencement date in the Act, thank you. At the top of the new Act or Amendment Act. So you look again at the Act itself to give you an idea of the date of assent. If not, from a Queensland perspective, have a look at Section 15, capital A of the Acts Interpretation Act. And for the Commonwealth, have a look at Section 3A of the Acts Interpretation Act. Okay, we're flying through it tonight. We're doing well. You're hanging in there. Commonwealth Parliament. We know what the Commonwealth does. We've seen some good information already. Let's go back to the Parliamentary Education Office. I'll share the screen. The Parliament of Australia, through its Parliamentary Education Office, has some great material. Some info sheets. So if you go to Parliament of Australia, go to About Parliament, or House of Reps, you'll see Powers, Practice and Procedure, info sheets, and that's a great little resource about some of the things that we're talking about tonight. If we go up one level, you'll see that the info sheets are part of a series of materials that will assist you in better understanding how this works in practice. So for more detailed information, have a look at information contained on this page. We'll copy that and we will go into the chat facility. Have a look at the legislation handbook. This is through the Department of Prime Minister and Cabinet. I'll share the screen to show you the legislation handbook, which is this one. So you can download that for free in PDF or Word version, and it provides the procedures involved in making Commonwealth laws, and you can even listen and it'll guide you through. So that's all part of the Resource Centre. If we go up a page, you'll see that there's further information there as well. Okay. I won't give you the link to that one. I'll let you sort that out and find that for yourself. So what you can see is that there's great information, particularly on the Parliament of Australia website when it comes to dealing with issues about legislation. The Queensland Parliament website's pretty good too. We now know what a bill is. Just a small thing, don't capitalise bill, but do capitalise the word act when you're referring to a piece of legislation. Make sure it's in italics as well. copies of the bill and the second reading speech explanatory memorandum, I would normally go to the Parliament's website to look at that, but you can find it elsewhere. You can certainly find these things through Austlii or through the legislation register as well. But usually I go to the Parliament website for that. Acts and Australian law, have a look at the Federal Register of Legislation and have a look at Austlii. Hansard, you should know how to find that straight away. And don't forget the work of the committees, and you can read about that as well. So having a look at the education resources prepared by the Parliamentary Education Office, which I've referred to a few times tonight, is really worthwhile. Again, I'll share the screen just to show you more precisely what it is that I'm talking about now. Again, I showed you about Parliament before. Here are some of the education resources, and that's the Parliamentary Education Office. So that's where you can find it. Queensland has good information on its website, and it talks about the work of the Assembly, bills, legislation, record of proceedings, so you can find Hansard records there as well. And don't forget delegated legislation. You'll need to understand how that works. We talked about the reality of parliaments not being able to make laws that deal with all sorts of finer issues. So delegated legislation allows for the executive effectively to make laws and keep those laws up to date. The Instruments Handbook is a handy resource. I'm now bouncing back to the federal sphere, and you'll see the third one down here is Instruments Handbook, and that's from the Office of the Parliamentary Counsel. The Instruments Handbook is updated, and it provides information about some of the key concepts that we're talking about tonight. The rule makers, legislative instruments, the drafting and interpretation of instruments generally, and sunsetting. So that's through the Office of the Parliamentary Counsel, and you should be able to find that pretty easily through the documents section. Again, I won't give you a link to that. Now, one thing we've talked about tonight, we have touched on it the last few weeks as well, as the Crown. So can anyone tell me what we mean by the Crown? I'm not just talking about the, a tiara type thing. What do we mean by the Crown? What does the institution of the Crown mean? The sovereign, that's a good one. Yep. What else? What does it do? How does it come into existence? What's the source of its power? Who is the Crown? Normally the prosecution, yes. In a criminal law sense, we often see prosecution, the Crown against somebody. Well, who is this Crown? How do I get to meet the Crown, him or her? The Queen's representative, yes. The government legal rep, yes. Parliament, no, I don't know about Parliament. The Attorney General, yeah. The Attorney General is certainly involved in being part of the Crown. I mean, I think I've mentioned this before. In trying to conceptualise this, firstly, you need to look at the Constitution, and you'll see that there's some reference to the source of the Crown's power. That's the federal legislation. Crown's like the household. So the individual players, the people in charge of the household, they come and go potentially, but the household is always there. So, it might be that dad's in charge of the household during the 80s, and then during the 90s, mum's sort of in charge of the household, but dad's still there. And then, during the 2010 and beyond, the kids take over and they're in charge of the household, and mum and dad are sort of in the background. So individuals that are actually in charge sort of change, but the household is always there. I hope that makes sense. It's a very vague way of defining it, but it's the best I can do. So yes, you'll need to read about the Attorney General's role. the as the Queen's representative, the Governor General, then the Attorney General, and try and work out how that works in practice. And the practical importance is, we've touched on one, giving assent to legislation. Number 2, prosecuting matters. Number 3, you'll find on title deeds, for example, that land and natural resources subject to native title derive from the Crown, and sometimes things are retained by the Crown on the title, such as mining rights and petroleum rights as well. So if you look at a title deed, you'll see that reservation about the Crown. So the Crown isn't the government. The government is responsible for the affairs of the Crown, is another way of putting it. And sometimes you'll read about legislation being expressed to bind the Crown. What does that mean in practice? In practice, it means that the legislation applies in its effect just as much to the institutions of government as it does to you and me. All right, so we are getting close. You're doing well. A few things that I want to cover before we leave. Case law, we've talked about. Have a look at the flowchart on page 163 of your text. It's got a good overview, but the Federal Magistrates Court doesn't exist anymore. What's the Federal Magistrates Court now? Who can tell me that? See who's on the ball out there. Nobody knows what the Federal Magistrates Court is now? Supreme, no. So it's Commonwealth. We know that because of the... No, it's not the High Court. The Federal Magistrates Court, and you'll see it at the bottom of the hierarchy on your flowchart.
Sorry, John, is it the Federal Circuit Court?
That's it, exactly. Thank you, Jackie. It's the Federal Circuit Court. That's it. And Tom got that as well at the same time. So sometimes the information changes. That's why I do refer you back to websites, because the information potentially is a little more up to date. You'll need to have an idea of where you can bring certain matters and the jurisdiction. So going back to some of the things we talked about at the start, common law and equity, not every court or tribunal has full jurisdiction to deal with equitable remedies. So you really can't go to the magistrate's court and ask for an order for specific performance, which is a kind of high-powered equitable remedy. Only some courts have equitable jurisdiction in a more specific sense like that. And also, thinking about the courts, need to think about the jurisdictional limits, the money limits. Did we do this last week? We'll just do a quick quiz. All right. So what's the monetary limit for the Magistrates Court? The money in Queensland. We're getting some answers. 25, higher than that. 75, higher than that.
Is it 150?
150, Deb's got it. Yes, that's it. 150, Benjamin just got pipped on that one. What's the jurisdictional limit for the District Court? You knew that was coming as the next question. 750, Tom's got it. Exactly. $750,000. Jurisdictional limit for the Supreme Court? Queensland, we're talking. Unlimited. Spot on, Mary. That's it. Jurisdictional limit for the minor debts division of QCAT, Queensland Civil and Administrative Tribunal.
Is it 5,000?
No.
No.
Ben says 10. 2,000 says Tom. No, more than that. More than that. 25. Ben's got it. That's QCAT minor civil disputes jurisdiction. But QCAT, the MCDs is just one part of QCAT. So for the rest of QCAT, what's the jurisdictional limit? It does look like you're bidding for something. What's the jurisdictional limit for QCAT other than minor civil disputes? 100,000 says Mary. No, more than that. 125, more than that. Higher. Ben says higher. 250 says Mary. No, higher than that. Who's going to be the winner of this auction? 500? No, more than that. 750 says Tim. Higher than that. 100. 1.5 million. No, higher than that. 1 million. No, higher than that. Unlimited. Yes, Diane's got it. Finally, you wore me down. Finally, it is unlimited. So in QCAT, if it's a minor civil dispute, it's $25,000. Otherwise, it's unlimited. Then you have 150, 750, and unlimited. All right. And on that note, we're just about ready to go. I want you to know how to address a judge or a magistrate in court or socially. The reason I want you to do this, I want you to feel as though you are part of the profession now. What if you go to a function and a district court judge is there? How do you address a district court judge at a, Your Honour? You can, yep. In court, it's most definitely Your Honour. But at a private function, not necessarily. I would tend to use a different term. Judge Smith, yes, you can do that. Sir, or that's always good. In the profession, normally it's just judge. So if you're having dinner with a district court judge, it's quite polite and proper to simply say, Judge, would you like some wine? Or Judge, just interested in your thoughts on this. So you don't have to say Your Honour. You can, but you don't have to. If it's a magistrate or tribunal member, normally just Mr. or Mrs. or whatever it might be. But in court, it's Your Honour. What do you call a magistrate in Queensland in court? What's the proper term, the form of address? No? Your Honour. Yep, that's it. So magistrates in Queensland, Your Honour, same as judges. It used to be Your Worship, but that was changed, I don't know, 10 or 15 years ago. I remember when that change came in, we would have almost like a fine jar, because people like me that were just so used to saying Your Worship, you lapse back into it and you'd immediately correct it. You have to put $2 into the swear jar almost. But it's Your Honour. If you're dealing with a tribunal member, it's member. All right. I had a few other things that I wanted to talk to you tonight, but we've just about caught up for the, week 3. I'm still behind. So what we're going to do is we're going to do this. We'll catch up by you doing a lot of private work, and we'll continue on with commentary, which is effectively week 4 material, when we resume in the live session in 3 weeks' time. All right. So next week is a break. The week after that, there's no live session because I'm going to pre-record a series of legal research, and I want you to work on that just privately. And then the week after that, we've got the live session again. So is that whatever number of weeks that is? I can't work that out. Okay. Any question? Is there a history for the Your Honour? That's a good question, Jessica. I don't know, actually. I don't know the background to that one. All right. Well, thank you very much. You've been very patient, and we'll see you live in a few weeks' time. Okay. All the best. Bye then.